Good afternoon. My name is Renee Townsend, and I'm an executive partner at the Michigan-based law firm of Seacrest Wardle. Today's presentation is on the premises liability topic, Special Considerations for Landlords. This webinar is targeted specifically to residential landlords, so we won't touch a lot on commercial leases. We'll focus on the legal issues that residential landlords may face, and specifically about the laws that affect landlords in Michigan. So without any further ado, let's get started. When we talk about premises liability, we're often talking about landowners, but the term landowner is kind of misleading because a landowner is not the only person who may be liable in a premises liability case. So we need to get a little bit of this background before we can talk about the things that are specific to landlords. The real issue in a premises liability case is possession and control of the subject property. Normally, the only proper defendant in a premises liability case is the entity that had possession and control over the property. So ownership is not dispositive, legal title is not dispositive. Liability depends on the actual possession and exercise of control over the property. But here's an important distinction. For a landlord, ownership does keep the landlord liable. Ownership of the land keeps you liable even if you have relinquished possession and control to another party, like a management company. That other party will just also have duties to the plaintiff in your case. So you can't give up those duties as a landlord, but you can share them. Something that often comes up as a question is whether certain areas are considered to be under the possession and control of the landlord, such as berm areas or driveway approaches. And berm areas are the grassy areas between a sidewalk and street that you typically see. Now, those areas are almost always subject to an easement held by the municipality or the city in which the property is located. So therefore, the landlord does not possess or control that area and owes no duty with regard to that area, even when local ordinances require the landowner to maintain that area and clear it of growth and different things. The same thing deals with driveway approaches. So you've got duties with regard to the driveway, but that apron or approach from the street just before the sidewalk to the driveway, the same rule would apply, even if you have a duty to clear the snow and ice on that approach. Now we can talk specifically about duties that apply only to landlords, and those statutory duties come to us through the Landlord Tenant Act, which can be found at MCL 554.139. Now, the plain language of MCL 554.139 states that a landlord has a duty to keep the premises and all common areas fit for the intended use by the parties, and to keep the premises in reasonable repair during the term of the lease or the license, and to comply with the applicable health and safety laws of the state and local unit of government where the premises are located. Common areas is an important term to keep in mind for this. Common areas are areas located within the parameters of an apartment complex, accessible to all tenants, maintained by the landlord or his employees, like the sidewalk, the grassy areas, basically all of the areas that are for the use of everybody who lives at the property, all the tenants at the property. Would not include an individual's private unit. It should also be noted that the obligations made by this particular statute can be modified by a lease or a license as long as that lease or license has a term of at least 1 year. The statute also specifically states that it should be liberally construed and that giving the tenant or lessee an opportunity to inspect the premises before entering into an agreement does not free the landlord from these statutory duties. So we've talked about the statute, we've talked about kind of the basics of what the statutory requirements are for landlords. Now let's talk about a very common law defense, the open and obvious defense. And most of you are probably aware of the open and obvious defense, which essentially states that a landowner is not liable to an invitee for a condition on the land that's readily observable. So something open and obvious. However, the open and obvious defense cannot be used to avoid a specific statutory duty. In the case of a landlord, the open and obvious defense does not apply to cases where plaintiffs are claiming breach of a statutory duty, like those imposed by the Landlord Tenant Act. So, for instance, the open and obvious defense does not apply to a landlord's duty to keep its premises in reasonable repair. keep the premises fit for its intended use, or follow local ordinances. So basically, if a plaintiff claims you did not keep your premises in reasonable repair, or you did not keep the premises fit for their intended use under the statute, you can't make that open and obvious defense. However, if the plaintiff fails to prove a breach of that statutory duty, so they claim it, but they actually don't meet the requirements of the statute, the open and obvious defense does again apply because there was no breach of that statute. I want to quickly make a couple of specific points relative to statutory duties of landlords and the open and obvious doctrine. First, with regard to social guests, the Michigan Supreme Court has held that the duties imposed by the Landlord Tenant Act exist only between the contracting parties, being the landlord and the tenant. Therefore, the statutory duties do not apply to social guests of the tenant or lessee. What this means is that a social guest cannot claim, for instance, that the landlord failed to keep the subject premises in reasonable repair to avoid the open and obvious defense. The open and obvious defense will apply to that social guest. The next thing is, the question may arise of whether a landlord owes the statutory duties that we discussed before as related to a fixture on the property. Now, the term fixtures generally means any personal property that's affixed to the real property. It's hard to define, but perhaps the clearest answer was offered by Professor Steve Nippenberg of the University of Oklahoma College of Law when he said, "You take the world, you shake it, and everything that doesn't fall off is a fixture." Some samples of possible fixtures include anything from furnaces, sinks, countertops, solar panels, wind turbines, things like that. A landlord generally does not owe those statutory duties in the Landlord Tenant Act relative to claims involving fixtures. For example, one case held that where a pilot light went out on a furnace and the landlord instructed the tenant to relight it himself, leading to an explosion and fire, the landlord was not liable for statutory claims made under the Landlord Tenant Act. And finally, I want to discuss the issue of notice. Where a landlord does not have notice of an allegedly defective condition, Michigan courts have held that the Landlord Tenant Act does not apply. For example, in one case, a plaintiff attempted to close a sliding glass door, but it wouldn't close properly. So the plaintiff pushed on the door with both hands in an attempt to close it completely. And in doing so, the plaintiff's right hand slipped and went through the glass pane in the door, and she sustained serious injuries. The plaintiff asserted a breach of the statutory duties under the Landlord Tenant Act, but the court held that because the landlord was not on notice of an allegedly defective condition, i.e. the defective door, the statute did not apply. This same principle applies most frequently in Michigan in snow and ice cases. In case you're unaware, Michigan winters sometimes produce snow and ice, and sometimes Michigan winters dump ungodly amounts of snow and ice on Michigan residents who question why we even chose to live the one life we have on this earth in a frozen tundra for 5 months out of the year. That aside, the Michigan Court of Appeals has repeatedly held that a landlord must have had actual or constructive notice of the existence of the alleged icy or snowy condition to trigger a duty to diminish the hazard. Absent some evidence that the icy condition had existed for any length of time sufficient that the landlord should have known about it, or that the landlord actually knew about it, there's no basis for liability against the landlord. However, notice is not the only hurdle that plaintiffs must overcome in a snow and ice case. Michigan courts have held that a landowner can still be liable for an open and obvious condition where that condition had some special aspect. A special aspect can be a condition which created either an unreasonable risk of harm to the plaintiff or a condition that was effectively unavoidable by the plaintiff. The touchstone of the special aspects analysis is that the condition must be characterized by its unreasonable risk of harm. So an unreasonably dangerous hazard must be just that, not just a dangerous hazard, but one that is unreasonably so, and it must be more than theoretically or retrospectively dangerous. Similarly, an effectively unavoidable condition must be an inherently dangerous hazard that a person is inescapably required to confront under the circumstances. Now, that said, it's not a landlord's duty to guarantee that ice never forms anywhere on its property. As long as you provide a reasonable means of ingress and egress, meaning you clear your walkways and sidewalks, you've met your duty under the common law. If Grandma Josephine wants to walk on unsalted and unplowed snowbanks, she does so at her own risk. All premises owners in Michigan have the same duties and protections with regard to snow and ice. However, landlords in particular have additional statutory duties under the Landlord Tenant Act. As we discussed earlier, a landlord has a duty to keep the premises in reasonable repair and fit for its intended use and purpose. There are certain rules to keep in mind when it comes to snow and ice, and these stem from both statutory duties and the application of those duties to the common law. The Michigan Supreme Court has held that parking lots and sidewalks in leased residential areas are common areas under the Landlord Tenant Act. The natural accumulation of ice and snow is subject to the lessor's duty, but a plaintiff must show that the area was not fit for its intended use under the statute, which provides that the lessor has a duty to keep the common areas fit for the intended use. The landlord's duty in this regard concerning the accumulation of snow and ice is to keep the entrance to and exit from a lot clear, to make sure that the vehicles can access parking spots, and that tenants have reasonable access to their parked vehicles. There have been cases in which a tenant has alleged to have slipped and fallen on ice in a parking lot, only to have that case dismissed because evidence was presented that other people were able to walk through the parking lot without falling. The courts have held that to be evidence that the parking lot was fit for its intended use. But the natural accumulation of snow and ice is not subject to the lessor's duty established in the second part of the statute, Part 1B, which concerns damage to the property and the landlord's requirements to repair the damage. The courts have held the accumulation of snow and ice does not constitute a defect in the property, and therefore the lessor would have no duty under Part B with regard to snow and ice, except to the extent that such snow and ice cause damage to the property. A final note on snow and ice. If you're a landlord who's renting out a standalone house, you can draft a lease that specifically puts the responsibility for snow and ice and other maintenance on the renter. This eliminates the statutory and common law duties of snow and ice maintenance that follow. Let's focus for a few minutes on how the statute has been applied to different common areas that are typically found on leased premises: sidewalks, driveways, and parking lots. Michigan courts have generally defined what the intended use and purpose of each of those areas are as follows. As we discussed earlier, a landlord has a duty to keep the premises in reasonable repair and fit for its intended purpose. It follows then that to determine whether a premises is fit for its intended use and purpose, you'd have to first determine what the intended use and purpose of a certain area is. For this analysis, sidewalks are not equal to driveways, are not equal to parking lots. Sidewalks have been held to be intended for pedestrian use. Driveways are intended for pedestrian use and parking vehicles. And parking lots have been held to be intended for parking vehicles and pedestrian access to parked vehicles. The intended use and purpose of a driveway and a parking lot seem pretty similar, but often courts have held driveways to be more akin to sidewalks if there's evidence to support that the intended use of the driveway was for pedestrian traffic, such as granting access to garages and residential units. I want to focus on driveways and parking lots for a second. So while at first glance it may seem like the intended use and purpose would be the same, like parking vehicles, allowing people access to their vehicles, they may not necessarily be treated equally. Driveways that grant access to garages and residential units may be deemed more akin to sidewalks and parking lots, like I said before. However, just because someone uses a driveway to access a certain area on foot does not automatically make that area akin to a sidewalk without some evidence to support the claim that the intended use of the driveway was for pedestrian traffic. This becomes evident when you compare two recent decisions from the Court of Appeals, one in 2016 and one in 2017, Hendricks v. Lautrec and Duff v. J. Wellington Enterprises. In Hendricks, plaintiff alleged that an icy path on the driveway caused from the path of runoff from a downspout was a dangerous condition that rendered the driveway unfit for pedestrian use. The court took note of the Michigan Supreme Court's decision in Allison v. AEW Capital Management, which held that the primary use of a parking lot is to park cars, and the statute does not require a lessor to maintain a lot in an ideal condition or in the most accessible condition possible. but merely requires the lessor to maintain it in a condition that renders it fit for use as a parking lot. But the Hendricks majority ultimately concluded that a driveway is not a parking lot, noting that the driveway on the premises in question was used for pedestrian access to the garage and residential units. In these senses, the majority held, the driveways are more akin to sidewalks. Sidewalks, the court noted, are intended for the use of pedestrians. The court concluded that where a substantial portion of the driveway was covered in ice, this ice created a dangerous condition, making the driveway unfit for pedestrian use. However, 1 year later, the Court of Appeals issued another decision, Duff v. J. Wellington Enterprises, which appears to be at odds with the decision set forth in Hendricks. These conflicting decisions indicate that the determination of whether a driveway is fit for its intended use and purpose may be fact-specific. In Duff, plaintiff was injured when he slipped and fell on black ice while walking on an asphalt driveway at a campground where he lived and worked. Plaintiff sued his landlord and argued that the area of asphalt that he slipped on, which was part of a driveway but also ran adjacent to a convenience store and may be used for foot travel into the store, was unfit for its intended use of pedestrian travel, given the slippery conditions. The dispute concerned the actual intended use of the area. Plaintiff claimed that it was for walking, with the only evidence being that plaintiff himself was walking in the area when the slip and fall occurred. The court found that the primary intended use of the driveway was in fact to accommodate vehicular traffic, and further that there was no evidence that the roadway was unfit for vehicular use or accessing vehicles. The court noted that plaintiff's unsupported assertion that the subject area was intended primarily for walking does not create a question of fact sufficient to survive summary disposition. The court cited Wilson v. Taylor when it stated that an appellant may not merely announce his position and leave it to this court to discover and rationalize the basis for his claims. Here, the plaintiff made claims that the area was intended for walking, yet when the court pressed him to support those assertions, he was unable to do so, and summary disposition was upheld. So this is a question that will likely have an answer that continues to evolve, and which will be very fact-specific in your premises cases. You and your counsel will have to determine whether the facts in your case involving a driveway lean more favorably to comparisons with a sidewalk or to comparisons with a parking lot. Let's zoom in even further on just parking lots for a second and talk about two recent cases that dealt with these particular common areas. We know a landlord has a duty to provide reasonable access to parking spots in a parking lot. In Coppola v. Edward Rosensons, the court held that this duty is not expanded or otherwise elevated in any way for handicapped persons accessing handicapped spots. The duty is still to provide reasonable access to those parking spots. We also know that a big problem that often comes up in snow and ice accumulating between parked cars and parking lots, even after the parking lot's been plowed. Snowplows can't necessarily reach those areas, and they may still have more accumulation that was removed from other areas. In Amin v. Village Park Preservation, the court held that the accumulation of snow and ice between parked cars does not render the parking lot unfit for its intended use and purpose. All right, we talked a lot about snow and ice. It's finally beautiful in Michigan, so I don't want to talk about snow anymore. With Michigan summers, the snow goes away, the maple trees come alive, the lake warms up, and the bugs come out. So the question is, what duty does a landlord have with regard to bug infestations? And the answer is, none really. Unless the plaintiff can prove that there was damage to the premises that was caused by the spiders or other bugs, or continuing presence of those bugs, it cannot be established that the landlord failed to keep the premises reasonably repaired as required by subsection B of the statute. A big issue recently has been bed bugs, which follows that same line of reason. Unless the plaintiff can prove that the landlord did anything that would have contributed to the bed bug presence, liability cannot be established. Moreover, there have been cases that have applied MCL 125.474 to hold that the duty to maintain the cleanliness of parts of the premises that tenants occupy and control is actually a duty of the tenant. Another issue, aside from bugs, that comes up a lot is dogs, and pit bulls in particular. Michigan courts have rejected the argument that property owners should be strictly liable for attacks by their tenants' dogs. Unlike dog owners, who are strictly liable for injuries inflicted by their dogs under the dog bite statute, more is required to impose liability on a landlord. A landlord is liable for injuries caused by the attack of a tenant's dog only where the landlord had actual knowledge of the dangerous propensities of the dog and where the landlord, having that knowledge, nevertheless leased the premises to the dog's owner, or, by the terms of the lease, had the power to control the harboring of a dog by the tenant and neglected to exercise that power. In short, such cases often turn upon whether the landlord knew that the dog had exhibited dangerous propensities before the incident. With pit bulls in particular, it's been argued that a landlord should be held to have known about a pit bull's dangerous propensities just by the supposed violent nature of the breed. However you feel about pit bulls, the point remains the same. The landlord must have known about that particular dog's dangerous propensities and not just about the danger of the breed in general. Even where a lease sets forth rules and regulations about keeping pets in a rented property, the landlord has no duty unless he knows about the dangerous propensities of the dog. Now, though spiders and bedbugs and pit bulls may be scary to some, the issue of criminal activity is another concern for landlords. Michigan courts have held that a landlord owes a duty both to tenants and their guests to take reasonable measures in response to an ongoing crime that takes place on the premises. This generally means calling the police. Landlords are not expected to fight crime themselves. The Supreme Court has also held that landlords have no duty to respond to criminal activity within rental units. A landlord's duty arises only when the triggering conduct occurs in those areas under the landlord's control. A final couple of quick points before we wrap up. What about condos? Condominiums, condominium owners, and condominium associations are not covered by the Landlord Tenant Act because there is no landlord-tenant relationship and no lease involved. Those are typically covered by the Condo Act. For example, a recent Michigan Court of Appeals case, Francescotti versus Fox Chase Condo Association, involved a claim by a condo owner against a condo association for an alleged defect in the common area on the property. The Michigan Court of Appeals held that even the common areas are not subject to any duty under the Landlord Tenant Act because they're not covered by a lease. Instead, premises liability cases involving condos are governed by the Condominium Act and the duties and obligations set forth therein. MCL 554.633, commonly known as the Truth in Renting Act, states that a rental agreement shall not include a provision that does one or more of the following: waives or alters a remedy available to the parties when the premises are in a condition that violates the covenants of fitness and habitability required pursuant to MCL 554.139, and exculpates the lessor from liability for the lessor's failure to perform or negligent performance of a duty imposed by law. Exculpatory clauses in residential leases have been held to be void as against public policy. Finally, all of the things we've discussed today deal with residential leases. I'll give you a quick note on commercial leases. A commercial lease is treated as any other contract, so unlike residential leases, you can have all the good stuff. Commercial leases may include provisions for indemnity, releases, exculpatory clauses, switching responsibility to tenants, shifting possession and control to tenants, making tenants identify you as additional insured, shortening statutes of limitations, and other provisions which may be particular to your property. So they're not as limited. All right, we've reached the end of the presentation. I hope this information has been helpful to you and gives you a better understanding of the duties, obligations, and protections afforded to landlords under the Landlord Tenant Act and the common law in Michigan. My contact information is now on the screen, or you can look me up on our website, www.seacrestwardle.com, or on LinkedIn by my name. I look forward to hearing back from you with feedback, questions, or my strong preference, compliments, and accolades. Enjoy the rest of your day. Thank you.